Hi guys, welcome to the channel. My name is Niladri Mukherjee and I'm a regulated Canadian immigration consultant. I practice here in Guelph, Ontario. So a lot of time people come to me for a consultation and they tell me that their application for visit visa particularly has been refused because of their dual intention. Hence I thought to make a video to let all of you know what really dual intention is and why an application could possibly be refused, stating that you have a dual intention. So what is dual intention? Dual intention, as the name suggests, you have two intentions. So one intention is obviously for you to come to Canada and settle here permanently, either through express entry system or through a provincial nomination program. The other intention you may have is to visit Canada temporarily while that other application is ongoing. Let's just give you a live example. For example, Mr. A has received a provincial nomination from Saskatchewan, for example, and has submitted all his documents while awaiting for a decision. We all know that for a provincial nomination, the decision time is quite long. For example, in case of Saskatchewan, the decision time is 2 years. Now, in that 2-year time zone, the person wants to visit Canada. Maybe simple for a tourism purpose. Maybe the person wants to see his family. Maybe for some other reason. So in that case, the person is having a dual intention that while he is having a temporary, while he's having a permanent residency application ongoing, he still want to come to Canada on a temporary basis. And this is perfectly legal to do so. You have a right, you have a legal right to make a temporary resident visa application, to make a tourist visa application for Canada while you have a permanent residency application pending, right? So, but in that temporary resident visa application, in the tourist visa application, you have to categorically mention everything. What you really have to prove in that particular application of temporary residence, like all other temporary resident visa applications, is that you will leave Canada at the end of your stay. So there is no connection between you having a permanent residency application ongoing and that you coming to Canada on a temporary basis, as long as you are able to prove that your stay for your intention for the temporary stay is purely temporary and that you will leave Canada. What people sometimes fail to understand is that the intention is dual because I have a permanent residency application and hence I cannot lodge a temporary application. My application will be refused. No, your application cannot be refused, stating that you have a dual intent if your application is proper, if you are able to prove that you will leave Canada at the end of the stay during that particular application period. So this dual intention, the concept of dual intention is very, very specific to that temporary application that you are making for that specific application only. It does not relate to your other application, but it definitely is a good idea to explain everything in the letter of explanation that you already have a permanent residency application in place. The process is a little bit more complicated. There is a way to mention that in the letter of explanation, and if you need my professional assistance in that regard, send me an email, contact@nuvonation.ca. Shall be glad to assist you. Thank you, and I'll see you in the next video. Bye.